they then found out that they didn't know all the rules. And it ended up costing them hundreds of dollars, thousands in some cases.
What is up, you guys? Matt McKeever here, and so in today's video I got a special treat for you. And so I got Jon Kepler and Alicia to sit down and just kind of talk about their experiences with the Ontario Landlord Tenant Board. And so this is something in the Residential Tenancy Act in general, and this is something that people get so scared of, and as a first-time landlord I understand it's extremely intimidating. But they're completely self-taught in this. They're not paralegals. They have no real special advantages. They literally just put in the effort and learned about it. And so they're going to share some of their best tips and tricks with us. You guys need to watch this video.
We're going to talk to you a little bit about our landlord and tenant board experiences. One thing we focused on in our business was learning the law as quickly as we could and being in an informed position so that when we inevitably had landlord and tenant board issues, we were equipped to deal with it. The first issue we ever had was with a tenant who felt that we had moved them along illegally after we had agreed to end a tenancy and amicably agreed to end a tenancy. So we were taken to the board and forced to learn the system, and strangely enough, I think that was one of the best things that could have happened to us, because once I had to go to the board for the first time, I made sure to dig deep and learn as much as I could about the law and about my rights, and just ensure that I was protected as time went on and as further issues occurred.
And like, this was scary. Like, most people would be scared to death of what we went through for the first case.
Well, strangely, there are a lot of landlords who get remarkably far in their business and they try to avoid the board. There are people with millions and millions of dollars who will say things like, I've been to the board once, I didn't like it, I'm going to try not to go back. And our policy is that it's better to be prepared, it's better to know the law and know where you stand so that you can anticipate how things are going to go 2 or 3 steps down the road. Often these things end up in mediation where you're talking to a tenant or the tenant is saying, cut me a deal or give me a break. And you have to know what the circumstances are and where you stand so that you know whether or not they're entitled to make the request that they're making. And just to be prepared so that there are no surprises, so that you know it's either going to be outcome A or outcome B, and you can prepare accordingly.
And it's important to have that. Like, we've fought with the duty counsel many times, and they've said things that really didn't make any sense, and because we knew better, we were able to work something out. But like, people that didn't know any better, you know, they might have just caved to that. And it's actually sad because we see people all the time at the board, like landlords, that there's no help for landlords. There's just, you know, duty counsel for free for tenants before a case, but nothing for landlords. And a lot of them just go in there completely unprepared, and they don't know what they're doing, and they get bad judgments. But you know, that's why we want to anticipate what's going to happen and make sure we know the law, so we follow the law.
Yes, one thing that landlords don't know a lot of the time that they really need to be aware of is that tenants have what's called duty counsel, which, as Alicia said, the free lawyer that all tenants are entitled to at the Landlord and Tenant Board. So it's important to keep in mind that tenants have free legal counsel and you do not. So as a landlord, it's important to be experienced. You are professional, and so they expect you to know what you're doing, and if you're in a situation where you're not sure that you know what you're doing, they expect you to hire a paralegal or hire a lawyer yourself at your own expense. So duty counsel will always advise tenants in terms of what they could do that's in their best interests. Not exactly what's fair. They won't necessarily recommend something that's illegal, but especially in the mediation phase when it's all about negotiating, there's a chance that if you're not fully informed, duty counsel is going to tell your tenants about where your weak spots are or what their rights are when you don't really know what your rights are. So once again, it's important to know. We've had friends who were inexperienced, and even people who took their tenants to the board, and then once they were at the board at their own request, they then found out that they didn't know all the rules. And it ended up costing them hundreds of dollars, thousands in some cases. The landlords say, well, this was stressful, well, I'm just glad that I have closure. And at the end of the day, you don't want to say, I'm glad it's over and I'm glad that I know the size of the check I'm going to write. Instead, it's much better to know your rights and obligations going in and to defend yourself appropriately so that the deal is fair and it's not a deal where you're perceived as having more money than the tenant and then by default you writing the tenant a large check.
Yeah, exactly. And there's quite a few common mistakes that we see a lot of landlords make, and I'll just briefly go over some of them. So the most common one is just simple errors in your paperwork. If you're doing a standard N4 for non-payment of rent, many times we'll see people not put the unit number, not put the address correct, not put the tenant's name correct. Just simple things like that will cause your case to get thrown out and you have to start all over again. And we've seen too, landlords not quite sure what they're doing, so they'll just send out multiple N4s, all with errors, and then get to the point where they're at the board, and then it gets thrown out because the tenant was confused because they had so many N4s from all over the place that said different things. So, I mean, make sure your paperwork, you triple check it, get someone else to check it that knows what they're doing. It doesn't have to be a paralegal or a lawyer, although a lot of the times it probably should be. But just make sure that you have everything correct. Like, there's no excuse for not putting the address correct or misspelling your tenant's name, honestly.
And what the adjudicators at the board always explain to one of these poor landlords who's brought deficient paperwork is that their hands are tied. The law is the law. I feel that it's heavy-handed, at least in principle, to throw this stuff out. But as the adjudicators explain, in many cases they don't have a choice. If it's a misspelling of a tenant's name and the tenant says, oh, there's no H in my name, just change it, no big deal, and everyone initials, then perhaps things can proceed. But it's better if you don't take that risk. It's better if you check your paperwork very carefully, ensure that the termination date is correct, and just do everything very, very carefully. Make sure to do all the work ahead of time and then actually fill out the forms correctly just once so you don't have to restart.
Yeah, so that is definitely the most common one. Another one that we see very often is people using the incorrect papers. So an N5 is kind of the more standard for if you're interfering with reasonable enjoyment or if there's damage to the unit. So that's the one that you would use if, you know, the dog kind of ripped up the carpet or, you know, police calls for noise disturbances, things like that. So N5 is still voidable by the tenant, so they have a certain amount of time to correct the behavior, and then if they correct the behavior, they're still able to stay in their house. So that is usually the correct form for that, and many times we see landlords use an N7, which has a very, very high threshold, and it's not voidable at all. So it's full and final, and it's really only to be used in very, very serious circumstances, and even in those circumstances, it's not always guaranteed. So that's another really common mistake we see many, many times. N7's used, and the adjudicator will tell you right up, like, that's not the correct paperwork. Like, you're talking about forcing a tenant from their home. So that's really, really important to make sure you know what paperwork to use.
I understand that in just the last few minutes, we've given you a lot of information. But at the end of the day, if you're going to file with the Landlord and Tenant Board, or if you find yourself being brought in front of the board, it's very important that you arrive prepared. At the beginning, we weren't sure exactly what we were doing, and one of the ways that we worked to get this experience was simply to attend Landlord and Tenant Board hearings. Even when we didn't have our own cases, we would still find out where the hearings were taking place, and we'd ensure that we went and watched the cases unfold live. It's a public forum, so anyone is allowed to attend, and this is how we learned not just how to do things correctly, but we also learned what the common mistakes were. So we learned how to avoid the mistakes that most of our colleagues were making, and just ensure that we looked competent in front of the adjudicator and that we gave them everything they needed to hear our case. Additionally, there's a website called Canly, and you can go on and review case law. So it makes sense to go to that website and type in some search terms, type in the names of various notices, so type in N4 or N5, and read about the cases that have actually taken place where adjudicators have decided either for the tenant or for the landlord. And again, you get to see what the details are, what the common mistakes are, and frankly, you get to see a path from beginning to end in terms of what it takes to have a successful application.
Yeah, absolutely. And from the realtor side as well, it's extremely important if you are selling a tenant property or thinking of buying a property that has tenants in place, It's extremely important that you work with a realtor that has experience with that and knows what they're doing. Because we also see at the board many times, these clients that can't move into the house that they just bought, or other circumstances that's really bad. Clients get sued and it's just a really messy situation. So make sure you do your research if you're buying or selling a tenanted property, because you don't want to end up with the landlord tenant board.